authorizing a change of registered office address by a current occupant under the Business Entity Standard Treatment Act, and changing the information required in an amendment to the Articles of Incorporation for a cooperative, or is that correct? Okay, great. And with that then, a bill brief from the reviser.
Thank you, Madam Chair. Good morning, committee. Jason Thompson, Office of Reviser of Statutes. And as the chair said, this is HB 2660, dealing with some business entity filings and other related issues. Procedurally, the bill was requested in the House Committee on Elections by Mr. Clay Barker on behalf of the Office of Secretary of State. It was referred to the Committee on Judiciary in the House, worked and passed as amended, and then it passed the House on final action 120-0 and found its way over to the Senate and here today. You've got a fairly lengthy bill brief and a somewhat lengthy bill, but boiling it down to just a couple of the highlights, you've got a new section that provides for an address issue. You can change the address of a registered office of a covered entity if it's a residence address and the registered agent no longer resides at that residence address. So if you're the current occupant, you find that your address is still listed and that person no longer lives there, you have a mechanism to change your address in this new Section 1. And I think the conferees will get into sort of why this is needed and that there might be an issue in the law with getting these addresses removed. And that's the reason for this new section. Several of the sections that I've listed in the second paragraph of the bill brief deal with amendments to filing deadlines for business entity information reports made to the Secretary of State. And I won't go through each of those, but each entity has its own reporting and filing requirements. And this standardizes much of that language and picks the date of April 15 for most of them, rather than basing it on tax year and other things. And one of them is June 15 because that's the not-for-profit date that was in the current statute. So that's the second paragraph there, several sections, filing deadlines, business entity information reports. Then the next chunk that we could deal with is sections that are amended to remove references to a certificate of fact. There are 3 of those in the bill. It's a document or a certificate that isn't used, so the references are removed for that in 3 places that are still left in current law. The other couple deal with cooperatives, so I'll give you just a bit on those. Section 4, 5, and 6 are cooperative issues. Section 4 is amendments to a cooperative's Articles of Incorporation. There's some information in there that the Secretary of State doesn't believe is necessary anymore. I think it removes some reporting that standardizes that a little bit. Similarly, Section 5 and 6 makes their reports contain the same information required in other reports. Those are electric cooperatives and renewable energy electric cooperatives, if you're curious what those are. And then the last bit that I'll mention is some clarification to some terminology that's been changed over the last few years about certificates of reinstatement, certificates of revival, certificates of restoration. So there's a change in Section 14 to kind of clarify that terminology and do some cleanup that essentially we missed in the last few years related to those, the names of those certificates. I think that pretty well covers the high points. There were 2 things in here about partnerships and limited partnerships. The partnerships change is still in there to make some provisions consistent with other reporting and requirements. But the House committee, after being told by the Secretary of State that it was not needed any longer in the bill, removed the change about limited partnerships. So you'll see there's a strike in the title and there's a section of the bill that's struck. That's essentially to leave current law alone on those limited partnerships. The Secretary of State changed their mind about making that change and asked the committee to strike that section to leave it as current law. So that's what the House committee did. I think that covers everything I wanted to cover. Happy to answer questions.
Thank you. Is that one change that you just mentioned the only change that the House committee made?
Madam Chair, the House committee made that change and then made a couple other minor sort of language cleanup changes. I believe one is on page 2, line 9.
Yes, I see that.
And I remember removing the title piece and removing
And that's just some
the
language
section.
change. Instead of saying upon receiving, it says if the covered entity receives.
Right. And again, this is a new section, so we kind of crafted this to cover the situation of the resident agent no longer living at a residential address. And I think that change was because when the Secretary of State receives a form, they attempt to contact the covered entity, and then the upon receiving sort of implied that they would succeed versus if they receive it. So the language is more consistent between C and D that way. So yeah, a minor change, but probably an important one in terms of the law there. And oh, I found the other one. It's on page 20, line 28 and 29. They put back in the current law about an original copy executed by a governor. So just restored current law there on page 20. I think that was all of the changes that were made, and maybe the Secretary of State's representative could clarify if I missed anything, but essentially it was to preserve current law in a couple of places, and then to make that technical change in section 1 to make that language more consistent. So substantively, not really much that the House did.
Okay, yes. And any questions then? Senator Steffen.
Thank you. Could you help me locate under the certificate of revival part where they deleted the requirement that the original name of the corporation be included? Would you please help me find that? And no is not an option.
I'd be happy to help you find it. I'm trying to find where I referenced that in my bill brief so that I can make sure I get you to the right spot. Which one were you looking at?
We're dealing with certificate of revival, and I'm pulling that out of the supplemental note.
Okay, certificate of revival.
Supplemental note at the very top, first paragraph, second sentence. The bill would require the date of filing of the corporation's articles, et cetera, would remove the requirement that the original name of the corporation be included.
Okay. Had to read the supplemental note for the first time there, not my document. Good work by research though, so thank you for that. This is the one, yeah, okay, so you said certificate of arrival, that's one section. This is the other issue related to that.
Thank you. Any other questions? Yes, Senator Steffen.
Did he tell us where that was at?
Oh,
Yes.
I'm sorry.
Getting there, sorry, I had to
He's
find
still
it.
looking.
Yeah. So there's one section that's about the cleanup to certificate of revival. That's section 14. That's not what you want. I believe you want section 7, which I'm going to flip to and make sure.
Yeah.
Right. So section 7, which begins on page 6, and then the change on page 7 in lines 21 through 23. So the current law says for these certificates, you file, you include the date of filing of the original articles of incorporation, the name you were originally incorporated under, and the name at the time your articles or authority to engage in business were forfeited or void. And the Secretary of State, I believe, will explain that they only want the date of the filing of the articles and the name at the time the authority to engage in business became forfeited or void. That's all they need. They don't need the original information for whatever reason they can explain to you, but they decided they don't need that original information. They only need the current information or the final information. Good? All right.
Thank you. Any other questions? Seeing none, then we will invite our proponent conferee to the podium. Jameson Becker, Deputy Secretary of State, Director of Business Services. Please introduce yourself and welcome to committee.
Chair Warren.
Make sure your microphone is on, please.
There we go.
There we go.
Sorry about that. Chair Warren, members of the committee, thank you for the opportunity to testify this morning on House Bill 2660. It was mentioned that it passed 120 to 0. Basically, this bill comes about out of 5 years of effort on the part of our office to modernize filing systems. So we just recently moved off a 1980s filing system and into the future on January 22nd of this year. And so as part of that, as you go through and you modernize, you find all these things that are out of date or maybe just haven't been cleaned up in years as you're examining what the parameters of the new system need to be and what's most efficient for our customers. And so House Bill 2660 is born out of that. There's a couple things that are major improvements that we feel would benefit Kansans and Kansas businesses. First of all, you heard about the standardization of the date for filing. Currently, that is based on a tax year end, and that's a relic of the 2004 franchise tax. So whenever that was still in place, everything was based off of your tax year end and then subsequent months following. And so to try to communicate that to businesses is challenging. And so what this does is it standardizes dates for-profit corporations and businesses and not-for-profit businesses. And so that would just provide a clean messaging across the board, and it only affects or changes anything really for about 10% of the companies that we deal with anyway. And so we feel like this would be a good change for businesses in Kansas. Secondly, it simplifies the administrative process and lowers the cost for out-of-state businesses to do business in Kansas. And then you heard about the residential address issue with resident agents. That is born out of something that we bump into periodically. Maybe the most extreme example was we had a family that had moved into a home that was formerly where a resident agent resided. And the resident agent, once he moved, decided that white supremacy statements and rhetoric was a good idea. And the family at that residential address started getting hate mail and death threats and the like because his name and address was still on file with our office. Currently, there's no way that we can remove that. And so what this would do is it would just allow us to have a process by which that homeowner can notify us that they are not the resident agent and thereby have their name removed from our website. Just one of those things that nobody foresaw, but we believe would be beneficial for all Kansans. So in this case, we were able to help the gentleman out and get that taken care of. But this would just give us an absolute process in law to do that. Additionally, it does eliminate provisions for certain fees that are no longer needed. I think record searches are part of that. And so that's part of the process that, hey, if we don't need to charge businesses because it's something that we have brought online, we're happy to eliminate those fees. And so that would take this out of law to where we can eliminate that. In addition to Senator Steffen's question, we're trying to eliminate things that are getting a disproportionate number of rejections. So whenever somebody files a report with us, if it doesn't have certain information, we must reject it back to the person filing the report and ask for that information to be included. This is something where it's asking for historical information for the company and doesn't relate to our ability to file the document or the business's need to continue forward. And so that's something that we're looking to streamline for businesses, get rid of common rejection reasons if there's not a reason in law for us to maintain those. So does that help answer that question a bit? Happy to clarify any further. So basically, whenever someone files a report with our office, there's certain pieces of information that must be present in order to file the report. A lot of businesses don't have that historical data and they will leave it blank. Whenever they submit it to us, then we have to reject back because the law requires that we have that. And so this would be a common rejection reason where we're rejecting back to the company saying, hey, can you please provide this? And it delays the filing for the entity. So that's why we're asking for that provision to be removed. Other than that, I think that's the major stuff. There's several other minor provisions, and I'm happy to stand for any questions you might have.
Thank you. Committee, any questions? Senator Corson.
Thank you, Madam Chair. Quick question on the registered agent issue. Mm-hmm. Is there not a way to go about this instead is probably better, putting a requirement on the registered agent that if you are a registered agent and you move, that you have an affirmative obligation to change that address, to update that address within whatever the appropriate number of days is. And I mean, I ask that, I don't want to really muck up your bill, especially since it passed unanimously, but it seems to me like that's maybe another way to go about that, instead of putting the burden on the new homeowner who
Sure.
may have no idea that their address is even used as an address.
Yeah, that's actually a current requirement. And so you're absolutely right. That is the most straightforward way for that to be accomplished. Unfortunately, many resident agents ignore that whenever they move. And then we end up with the same situation. So it doesn't force this upon homeowners. It just provides them a means by which to accomplish this in case the resident agent doesn't do what they are supposed to do under law, which is update when they move. So thank you.
Thank you. So a follow-up question to that, if I may, just real quickly. So you've got a registered resident agent, which is required for service of process to
Right.
institute legal proceedings against the business entity. So if this provision would become law and you then have no registered agent or registered resident agent with a good address for our Secretary of State and for those who need to serve legal process on the business entity, where then does that leave the business entity and those who need to serve legal process on the business entity?
Sure. So the business then has to appoint a new resident agent within a certain time period. I believe it's 90 days, or that entity then falls out of good standing with our office. So in the meantime, our office serves as the resident agent for that business. And so if somebody were to want to file suit against that business, they would serve our office, and then we would attempt to serve process on the company.
Is there a provision in law that if the new homeowner changes the address of the resident agent by saying it's not this address anymore, is the business entity notified of the 90-day window starting? And if yes, how would they be so notified if there's no good address for the resident agent anymore?
Sure. So we would notify them via mail, and we still have a principal office address that we would send to as well. So
Thank you.
sure.
Senator Steffen.
Thank you. Now, again, I'm looking at this from an outside person looking in, wanting to use this database to glean information, and I look up a corporation,
Mhm.
and if they're able to revive a certificate, that means there's history that they're trying to keep in doing so. And if I'm wanting to look into this company, I'm going to want to know what the name of this company was beforehand, because that might lead me to a whole lot of information that I wouldn't otherwise know to look into.
Sure.
Am I off base on that? That would be deleted from the history of the corporation?
Sure. So that's an excellent question. It doesn't delete the language or the history at all. So this isn't retroactively deleting it from our database. This is just saying on this particular information report or amendment that they're filing with us, they don't have to include that data anymore because we already have it attached to that business's history. And so if you were to search by either name on our website, you would still pull up that same company. You would pull up two different names that would both be tied to that same entity. So you're not losing out on that data. It's an excellent question, but that's where it ties back in.
Fair enough. Thank you.
Sure.
Thank you. Other questions? Senator Bowers.
Thank you, Madam Chair. Hi, Jamison.
Aye.
Does it populate this information when we're filling out that form anyway, or is it blank start over from
So
nothing?
on this particular piece
Like-
that Senator Steffen
Mhm.
is talking about, it's blank, and so it's not there for the company to have. And so whenever they're trying to fill it out, they're having to dig back through history and figure out, what did Grandpa start the company as, right? They may have changed names a couple times over the course of their company history, and so this just allows them to submit it. We tie it back in automatically with the history of the company, and so it's just one less research project the company has to go to.
Is there a way to put that information in if you know it already with your new system?
I would have to check and see if it's something that we index. I'm happy to check and see if that's something that we already do. And I know with the new system, the first time we're going through, there's all this information that you're putting in, and then subsequently we'll be able to pre-populate a lot of it as well.
I know on other forms, like the Department of Revenue with my dealer's license, it's already filled in.
Yep.
And that's very, very helpful just to continue on. It makes it quicker on our
Yep.
end too. So that's a possibility. But thank you, Jameson. I
Absolutely.
appreciate what you're doing for us business owners.
Sure. Thank you.
Thank you. Senator Olson.
Thank you, Madam Chair. I just want to state, I think it was a week or two ago, I was over there refiling my business, doing the multi-year, and I normally do it from home, but it was new. I definitely get it's a much more secure system, and so I just want to say I appreciate what you guys have done there with the multi-year, and it's going to be much easier for business. It'll take a little while to figure it out. There's going to be some bugs, but I support what you guys are doing. You're making it way more business friendly, and these are some of the tools we need to give you to make sure of that. But the security on the information is incredibly much better than it was just a year or two ago with the old system. The old system was not very secure, I'm betting.
Yes. Yes.
It was so simple. It was, but I appreciate your help, and I'm sure you've got a lot of questions, but from businesses. But once they see it, and they're probably pretty happy, I imagine, being able to file 2 years, and it's just saving us time and money. And I know as a business, it's always nice to have 2 years, not one filing. You don't have to worry about that or miss that deadline. So thank you.
Thank you, Senator Olson. And yes, moving to the biennial system is something that happened in January as well. So we rolled out a brand new filing system, switched to biennial reports. And so we've really had a focus on helping customers understand the changes and that kind of thing, and servicing customers. So thank you for your kind words. And we're continuing to just help folks as they learn the new process for sure.
Thank you. And I think that 2-year change was a change that you had brought to the legislature. So Thank you for looking at that as well. And I have a question. You had mentioned the principal place of business would be where you would find the business entity after the registered resident agent had been declared. Well, that's not currently the address, and then there is none. You said you would serve or mail it to the principal office. So I'm wondering, with a cooperative, the proposed bill provides that a cooperative would no longer be required to include the address of its principal office. So would there be no principal office on record, or please talk about that for a minute?
Yeah, so we do try to standardize across all the different business entity types. And so for some, there are no principal office. We would send to the mailing address that we have on file. So I apologize for misspeaking on that, but we would send to whatever address we have on file, whether it be the principal office address or a mailing address. Obviously, the resident agent address would be no longer viable at that point. So in some instances, both addresses are bad, and that bounces back to us, and that shows that we have at least attempted to serve process for any court proceeding moving forward.
For business entities to receive service of process, again, for the legal system to contact them, or a party who needs to contact them to initiate litigation or things of that nature. Sometimes I think jurisdiction in one county versus the other is often dependent on where the principal place of business for the business entity is located. And we're then eliminating with this bill all requirements for an address for the principal office of any business entity to be included.
Let me check into the particulars of the service of process component. This change for a home address is very similar to how we process currently, and so it's not moving outside of that. I would have to get into the particulars of exactly how service of process flows. This is just attempting to help a homeowner that is in the situation, but I'm happy to provide that to you in more detail.
And I don't just mean for that homeowner
Sure.
situation. I mean, for instance, a cooperative wouldn't have to include the address of its principal office. So I'm wondering, is that standard? No more principal office address listed for any business entity?
Let me double
Okay.
check. I don't believe that that's standard across all entity types. It is trying to line cooperatives up with other entity types that are similar to them. I can get you the particulars on that. I don't know off the top of my head. I do apologize.
Because I would be wondering then how you determine where a cooperative's principal place of business is, other than I guess you would have to argue about it in court or make an argument about it. And so
There's already a process in place. I'm just not
If you could
familiar
just
enough with
get
it
that, that'd be
to
great.
give voice to it here, but I'm happy to provide that after the
And
hearing.
then you had said that the bill lowers the costs for out-of-state businesses by lowering fees, I'm thinking.
Yep.
And then I'm looking at the bill. The bill would allow the secretary to charge a fee of up to $150 for issuing, filing, or indexing a reinstatement. Is there currently zero fee and this is an increase, or what's
No,
the story there?
Still a current fee there for reinstatement. So with
There's no fee currently?
There is a fee currently. It's and let me look at the particular page that is on, and I can speak to that more clearly there. As far as the other fee goes with regard to lowering fees for out-of-state businesses, what that does is currently if a business is wanting to start doing business in Kansas, they're required to get a paper certificate of good standing from their home state. That fee obviously varies widely across all the different states. Then they bring that to us, they file it with us, and those certificates are good for varying amounts of time depending on their state they're coming from. Basically, after that certificate is issued, it ceases to be, their status in the home state can change at any point in time, right? So they bring that to us. It's basically as good as the paper it's printed on because their status can change immediately after printing that document or receiving it from the opposite Secretary of State. So this would just give us a statement that they are certifying under penalty of perjury that they are in good standing in another state rather than having to bring us a piece of paper that literally could have ceased to be good the day that it was issued from the other jurisdiction. Most states, I believe all states now have the ability for us to go check online and see if that entity is in good standing in the other state, and it's a more immediate process. And so it just eliminates that fee that the other state has to get and send to our office.
Okay, but I'm talking about the 150 fee that could be charged for, it looks like a domestic business
Sure.
entity. So on what page of the bill is that?
That's what
And what is the current fee and what's the increase then?
I believe the current fee is $120.
So, okay, $30.
Let me look here and see if I can locate that. Page 15. Thank you. All right. So this is talking about different certificates. And then we get into certificate of reinstatement. This is just listing it in a different section. And so currently it's just not listed with the rest of certificates. And so it's putting it into that section. The fee has not changed from what we currently charge, is my understanding.
Okay,
So this is current law. We're just moving it to an appropriate section.
Okay.
Yep.
Okay. Any other questions, committee? I'm not seeing any, but thank you for your testimony and thank you for the work that the Office of Secretary of State is doing to make it easier to operate and do business in Kansas. We appreciate that.
Absolutely. Thank you, committee.
And with that then, are there any other conferees wishing to testify as a proponent, a neutral, or an opponent on the bill? Not seeing any, then we will close the hearing on House Bill 2660 and open the hearing on House Bill 2628. requiring the Secretary for Children and Families to release certain information related to a child fatality when criminal charges are filed alleging that a person caused such fatality. And with that, a bill brief from the reviser.
Thank you again, Madam Chair. Jason Thompson, Reviser of Statutes. So House Bill 2628, as you mentioned, does deal with child fatality records, procedural background. This was requested for introduction on behalf of the Kansas Department of Children and Families. It was referred to Committee on Child Welfare and Foster Care in the House, and it passed without amendments on final action 119-0 and made its way to your committee. There's only one section to the bill. It's current law, KSA 38-2212. That's in our Kansas Code for Care of Children, the SYNC code, Child Need of Care code that you're all familiar with. It deals with access to information related to children alleged or adjudicated to be in need of care. The current law in subsection G3, which is pretty deep in the section, beginning on the bottom of page 4 and then on to page 5. The current law provides that in the event that child abuse or neglect results in a child fatality, the Secretary shall release the following information in response to an open records request within 7 business days of receipt, as allowed by applicable law. And then it lists the 4 pieces of information there: age and sex of the child, date of the fatality, summary of previous reports of abuse and neglect received, along with findings of those such reports, and department recommended services provided to the child. So this provision was enacted just a few years ago. Some of you probably remember when this came up and was placed in the law. The bill is an amendment to that subsection to also authorize that information to be released as allowed by applicable law pursuant to a request in the event that, quote, criminal charges are filed with a court alleging that a person caused a child fatality. And so you can see that new language there at the bottom of page 4 in line 43 onto the top of page 5 in line 1, essentially just adding in a new situation where a request comes in and then the information is released. And that would be when criminal charges are filed, rather than waiting for a child abuse or neglect results in the fatality. That's kind of a finding. I think you'll see that in the testimony, and this would allow it earlier and under different circumstances. So I'll let the conferees get into the reasoning behind it, but that's what the change would be. And I note it would take effect July 1st if adopted.
Thank you. Committee, any questions? Not seeing any, then thank you very much. And we will invite proponent conferee Laura Howard, Secretary, Department for Children and Families, to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Laura Howard, the Secretary for the Kansas Department for Children and Families. Thank you for allowing me to testify today in support of House Bill 2628. As the reviser indicated, we did request the introduction of this bill, and it does address the ability of DCF to release information to the public in the event of a child fatality. You know, as the Secretary for Children and Families, I've really tried to make transparency an important priority. I think that transparency and accountability, obviously, they're essential always in government, but I think it's particularly important as we think about the context of the child welfare system. I think when it's appropriate in the context of preserving confidential safeguards, I think it's best when information can be shared in certain sensitive situations. So what this bill does is propose an additional criteria under which my department could release limited information to the public in the event of a fatality of a child. Now, I might divert from my testimony just for a moment to say, if the child is in my custody, or in the custody of the state, when there is a fatality, another provision of the law already allows similar information to be released. So in this circumstance, when the child is not in my custody, this current statute would require that DCF complete its investigation and make a finding of abuse or neglect before releasing any case information to the public. Sometimes we have delays in being able to do that investigation and make that finding. And that typically happens when law enforcement is engaged. When law enforcement is performing an investigation, we often then pause our work, sometimes at the request of law enforcement, so that they can proceed with their criminal review. So what this bill would allow us to do, in the event that that action by law enforcement results in the filing of criminal charges, at that point, DCF would be able to release that very same information. And again, it's limited information. You can see that in the middle of my testimony. The information to be released would be the age and sex of the child, the date of the fatality, and a summary of any previous reports received involving the child and the findings of such reports, and whether or not my department provided any services. So again, today, in the same circumstance, if my department made a finding of abuse and neglect, we would provide that information. What this bill would do would be to say, in the event that criminal charges are filed, we could at that point provide that same information, even if my team has not yet made that abuse and neglect finding. I also think that what happens in this, with this amendment, this also would allow DCF to release information, obviously sooner, but often then more aligned with the same time frame under which law enforcement might also be releasing information. So I think sometimes when we have a kind of a horrific event and a child death, law enforcement may be able to release certain things, and then my agency is saying, well, we can't release that because we haven't made a finding. And they'll say, well, gosh, somebody's been charged with the death of a child. Why haven't you made a finding? Well, because we've stepped back to be out of the way of law enforcement. So again, I believe this is a very limited change that supports transparency in the system, while still maintaining important confidentiality safeguards. Child fatalities are obviously very serious events that we all grapple with, communities grapple with, and I think it's important to allow the public access to this limited information to understand what contact my agency has had with that child or their family in these circumstances. Thank you, Madam Chair.
Thank you. Committee questions? Senator Gossage.
Thank you to Secretary Howard for being here. I know, I recall earlier, of course, there was a child fatality, and you spoke to us in committee, on the Health Committee and Bob Bethel Committee. We had to go into private session because there were some things that you could not release, even though the police record or the police statement was already out there. So I'm assuming the impetus of this bill might have been that case. Is that right?
Yeah, thank you, Senator. Yes, partly. We did request this bill, a very similar bill, a year ago, in response to another incident. There've really been, I think, two incidents in my tenure, one in Wyandotte County, and then I think the circumstance you're referring to here in Topeka, where just the alignment of when information from law enforcement and when charges were filed, it created quite a misalignment and an inability of my agency to release information for what would have been, really several months because of the fact that we had stepped back and we were not engaging in the activities that would allow us to make our own independent finding.
And also, if I recall, there were accusations that were placed towards the department that you couldn't address because you had seen the child and you had a full record of contact with the child, with the parent, et cetera, but you weren't allowed to release that information at that time. Is that correct?
Yeah, thank you, Senator. That's correct. I mean, in the circumstance that Senator Gossage is talking about relating to the child in Topeka, Zoe Felix, but I think really in any circumstance, you immediately begin to get reporting that talks about, perhaps how many reports were made, those kinds of things, and rightly or wrongly, whether that information is accurate or not, the inability to provide just that basic data, I think, leads to a lot of speculation speculation. And from my perspective, whether or not what we would release would show something that is positive towards the department or not, I think it's important from the standpoint of public confidence in our system to be able to release that information.
And often rumor comes from lack of data.
Yes.
So the more data, but yet you would coordinate this. I don't see any opponent testimony from law enforcement. So they obviously feel this is okay.
Yes, that's correct.
Thank you very much, Madam Chair.
Thank you. Committee, other questions? I have just a procedural question. Thank you for bringing this bill forward. In the section on page 4, that subsection 3, where the amendment is found, it says in the event that child abuse or neglect, would there have to be a finding of the Department of Child Abuse or Neglect before this proposed amendment would require the disclosure of information?
Yeah, thank you for the question, Madam Chair. That's exactly what the bill is intended to address. So if you continue in that section, it now with the proposed changes would say in the event that child abuse or neglect results in a fatality or criminal charges are filed, we could, alleging that a person caused a child fatality, we could release that. Without this information, we had to make that finding before without this bill, we had to make that finding. And that's what we were often unable to do when we had kind of stepped back to allow law enforcement to do their work. So this is an or. So in the event that we make a finding, we could release this, or if criminal charges were filed alleging that someone caused the child death, we could release that same limited information. And that's really our intention with the bill.
Thank you for clearing that up, because oftentimes then the department would not have yet made its own finding that child abuse or neglect resulted in the fatality, but during an investigation pursuant to charged criminal files by prosecutors, the information from the department who had not yet made a finding could be released to, pursuant to a Kansas Open Records Act request.
That's exactly correct, Madam Chair. And that's exactly what we were trying to accomplish with the bill.
Thank you. Committee, any other questions? Not seeing any. Well, thank you for your appearance here today, Madam Secretary, and the work that you're doing on behalf of children and families in Kansas. Are there any other conferees wishing to testify as a proponent, neutral, or opponent? Not seeing any, then we will close the hearing on House Bill 2628. And we do have a few minutes, committee, for an opportunity to look at possible final action on bills previously heard. And I would like to bring up a couple that we heard last week. One of them is 2557 regarding peer support counseling for law enforcement. And with that, then, a kind of a short bill brief reminder from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. As you mentioned, this is the one regarding peer support counseling. The amendment is to the rules of evidence, the KSA 60-473 rules of evidence privilege statute that just says these services of peer support counseling that are provided to emergency services personnel, which includes law enforcement, those are privileged and confidential. They won't be used as evidence against them in other proceedings.
Thank you. Committee, any questions for the reviser? Not seeing any. Is there any discussion or motion on the bill? Senator Gossage, I saw first. Sorry, Senator.
Madam Chair, I move we pass House Bill 2557 favorably for passage out of the committee.
Thank you. Is there a second? Senator Stephan. Committee, you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. And committee, I think we're waiting on a couple of amendments on some of the other bills that we've previously heard. So that is going to conclude our work for today. I want to thank staff and committee for their work today, and those following along in the committee meeting room and online, as well as our conferees. With that, then, the meeting is adjourned.